Be ready, start. Learned Standing Counsel, on the other hand, submits that the petitioner cannot claim this continuance as a matter of right in as much as the state government has taken a policy decision and by virtue of the said decision, the collection of toll in relation to certain bridges and ferries has been withdrawn by the state government under the impugned government order dated 2/12/2016. This being in public interest cannot therefore be questioned, nor any claim can be made by the petitioner to continue the said lease in his favor. Learned Standing Counsel has invited the attention of the court to Section 15 of the 1878 Act to contend that after a lease has been let out in terms of Section 8, and if after such declaration any impediment is caused on account of any such contingency as has happened in the present case for collection of toll, then the party concerned shall be entitled to the adjustment of the rents that were payable under the lease agreement. He further submits that if there is any such dispute relating to the amount of collection of toll or deposit of the money by the petitioner, the same can be dealt with by the appropriate authority in accordance with law. Having heard the learned counsel for the parties, the question that arises is as to whether the petitioner who is under a contract is entitled to insist upon the performance of a contract which cannot now be executed, keeping in view the policy decision of the state government under the notification dated 2/12/2016. Having considered the submissions, what we find is that keeping in view the provisions of Section 15 of the 1878 Act read with the provisions of Clause 21 of the General Clauses Act 1897, the power is there with the state government and it can, as a matter of policy, withdraw its authority to collect toll on any bridge or ferry. Consequently, the power of the government is therefore available and the action cannot be said to be without authority in law. The question is about the impact of such an order on the petitioner's contract. The petitioner contends that this amounts to cancellation of the lease which has not been done in accordance with 1878 Act, that too even without affording opportunity of hearing or notice. Here the petitioner will have to face the principles of res judicata in as much as after the state government has taken a policy decision whereby the performance of the contract would become impossible, and secondly, in this situation a writ for the enforcement of the balance of the period of contract would not be maintainable, more so when the withdrawal of toll is in larger public interest. This is a surmounting interest against the individual contractual interest of the petitioner. The petitioner does not therefore have a vested right to claim the continuance of the contract after withdrawal by the state government through a valid policy decision. One of the arguments advanced by the learned counsel for the petitioner is that if a statutory provision is there which governs the file of the contract entered into, then any rights vested under the said statutory exercise of power cannot be taken away by way of a notification as has been done in the present case. We are not able to accept this proposition for the simple reason that the state government has issued the notification in exercise of its powers under the act, and we have already referred to section 15 of the 1878 act read with the provisions of clause 21 of the General Clauses Act 1897. Consequently, none of the arguments hold any water. The petitioner, therefore, may consequent to such withdrawal be entitled to get adjustment or claim with regard to the lease rent that may be permissible under terms and conditions of the contract and provisions of the 1878 Act as well as the rules in this regard.